Good morning, Liberty. It is Friday morning, April 12th, 2019. My name is Michael Bolden, broadcasting to you live from my home office and studio here in downtown Los Angeles, 9:30 a.m. Pacific time for the 10th Amendment Center. So good morning to you, or good afternoon if you're watching on the East Coast, or later on in the archives. Good evening, whenever you happen to be tuning in. I really appreciate you spending a little time with me on your Friday, or whenever, I guess that is. We are broadcasting through our channels over at Facebook, YouTube, Periscope, and Twitter. And of course, we have the archives over at 10thamendmentcenter.com/Good Morning Liberty. Now, today's episode is going to be an interesting one. I've wanted to cover this for a little while, and I wasn't sure the best, because it's a really, you can go down a rabbit hole with this and just, it'll take multiple episodes, and maybe that's what it'll lead to. But for those of you who have a case, a little touch of the TDS, you're not going to like this episode. You are going to be upset. And unfortunately, truth is not always a rosy thing. But I'm here to share with you what's happening. And of course, by TDS, I mean Trump derangement syndrome. And there are two types in my book. The people who have it in regards to being pro-Trump no matter what. People who, they don't want to hear a criticism. If you hear a criticism, or you hear of a policy or a viewpoint or a bad strategy or an unconstitutional idea, whatever it may be, you cover your ears, you get angry, you attack the messenger. You don't want to hear anything against Donald J. Trump. Now, there's the probably the more common type who, no matter what Trump does, good, bad, or in between, they're opposed to it. You could probably get some people on the left to be pro-gun if Trump would just keep ramping up the gun control. I don't know. It sounds silly, but maybe, because they're just opposed to everything. They're not showing any principles. So for that, I think there's two types. And in regards to this issue, it is very polarizing. I'm going to be talking about sanctuary cities. There's about, I think it's 12 or 13 cases so far, 12 or 13 federal district court rulings or opinions in about somewhere between 7 and 10 cases that are winding through the federal court system. Basically, what's happening is that the Trump administration is trying to take funding away. The localities or states are suing, and so far it's not going good for the president or their approach. And it's my view that the approach that they're taking strategically now is actually opening the door to making the immigration sanctuary cities even stronger. And for people who want to stop immigration sanctuary cities, this is not good news. Their strategy, I think, is really, really bad. Now, you may not like that, but that's how I'm seeing it, and I'll make the case for that. Now, on the other hand, people who absolutely want to see the sanctuary cities, they tend to be from the left. Generally, I'm generalizing, of course, and they tend to like more centralized power. They're like Hillary Clinton or Elizabeth Warren supporters or Kamala, whatever. They want, or Bernie, they want a big socialist centralized state. And for them, I think the bad news is actually in the long run, because their approach is actually going to make it more difficult, if it plays out the way that I think it will, or is very likely to, or is already playing out right now. It's going to make it more difficult for them in the future to impose their centralized so-called solutions. And of course, I've always held a view that if you're not pissing anybody off, you're not telling the truth. So let's get into some truth today about the sanctuary city cases. Before doing that, I want to say hello to some friends out in the live chat. Whiskey over on Periscope, good to see you. Welcome to the show. Jerry, Randall, Dan Reed, and Kelly over on Facebook. The Chicken Man, Robert, Justin, Tyler, and Turbo Jones. Really appreciate you guys being here with me on the show today. Of course, if you like what we're doing here, hit the thumbs up, smash the like button. If you hate it, vote it down. Whatever. Let me know what you think about the program. Of course, you can also leave some comments, share the link to the video, whatever else you want to do. I really appreciate all of it. They're all free and easy, and it helps us spread the word. So let's go over a few things. First of all, I want to remind everyone that back in February, I did an episode called The Anti-Commandeering Doctrine. Anti-commandeering, the legal basis for refusing to cooperate. I have a link to this in the show notes on YouTube. Of course, if you watch live, we have all the links on YouTube in advance, so you can actually look that up before the show even. We usually post them about a day in advance. But of course, all of our archives after the shows are done are over at 10thamendmentcenter.com/Good Morning Liberty. And this is basically an overview of the 5 major Supreme Court opinions from 1842 all the way to 2018 that cover what we're talking about. I'm going to briefly mention one here in a moment that I think is the most closely related. But this is the Supreme Court's position backing up James Madison's advice in Federalist 46 that states and individuals should use a refusal to cooperate with officers of the Union and disobedience to undermine federal programs. The Supreme Court has repeatedly upheld this position from Madison, and it's very, very difficult these days, and getting more difficult for the federal government to force states or their political subdivisions to really actually do anything. The court is just taking the states' rights side on this over and over and more aggressively. So that episode will give you a lot of the details. Primarily, the one case that I want to cover is the most recent. That was Murphy versus NCAA. If you followed this at all, it's the New Jersey sports betting case that actually the decision or the opinion on that came down in 2018. So this is only a year old. It is really, really new. And it wasn't one of these razor-thin ones. And the reason I think it wasn't razor-thin is because the liberal justices on the court are actually in a position now where, because they have their politics, anyone who tells you that the Supreme Court justices are apolitical is a total liar or completely ignorant. But the liberal justices are now more willing to support this anti-commandeering doctrine because it goes against the Trump administration. That's my view on it. Because back in 1997, the most famous of these was Prince versus U.S. This is where the Supreme Court held that the federal government couldn't require local law enforcement officers to help them enforce the Brady Gun Control Act. They were absolutely correct there. That was a 5-4 majority. And we've been pushing the strategy based off of that, refused to cooperate with officers of the Union for a number of years. And in response, major liberal professors, while Obama was in office, started pushing and publishing articles and commentary and talking about how this is an arcane idea and it should be overturned. But we don't hear that anymore now that Trump is in office. And the most recent case in 2018, Murphy versus NCAA, was a 7-2 vote on the Supreme Court. And here the court held that Congress can't take any action that, quote, dictates what a state legislature may and may not do, even when the state action conflicts with federal law. So the Supreme Court, now that I'm not one of these guys that say, oh, the Constitution means what the Supreme Court says it means until it changes its mind. So just setting aside that, they are repeatedly taking this position that you cannot require them to do things. And they were most aggressive in this New Jersey sports betting case. They said, even if what the state is doing is different than federal law or directly conflicts with federal law, Congress can't tell them to change what they're doing. Samuel Alito put it this way, quote, a more direct affront to state sovereignty is not easy to imagine. And he put it this way as well. The anti-commandeering doctrine may sound arcane, but it is simply the expression of a fundamental structural decision incorporated into the Constitution. The decision to withhold from Congress the power to issue orders directly to the states. Conspicuously absent from the list of powers given to Congress is the power to issue direct orders to the governments of the states. The anti-commandeering doctrine simply represents the recognition of this limit on congressional authority. So this is a recent opinion. It is widespread. It is used all over the place. And the court is actually ramping it up. Back with the gun control issue, it was 5-4. And now here, 2 decades later, it's 7-2. So, okay. That's kind of the basis. Now, we have to actually understand what's happening in the sanctuary city cases. There's been, I think, 13 federal district court opinions on this so far. They call them rulings all over the place. I don't like calling them rulings. But there's been 3 categories of them. First of all, the Trump administration's executive order. It was 137, 13768. This was in early 2017, where they said that they were going to start taking away funding or federal grants from sanctuaries or jurisdictions that they determined to be sanctuaries that aren't complying with 8 U.S.C. 1373. And I'll get into what that federal law on the books is right now. So they're saying if you're not certified that you're complying with 8 U.S.C. 1373, you risk losing all federal funding. And I don't think that the executive order actually intended to mean all, but it was written really broadly, and that's the way that the courts are looking at it. That's the way the opposition is looking at it. So the way it's playing out is that it's targeting everything or potentially everything. And it basically says, quote, "You're not eligible to receive federal grants except as deemed necessary for law enforcement purposes by the AG if you're not in compliance with 8 U.S.C. 1373. That's one category. That was Trump's executive order. Then the second category is a revised version of this that came from former Attorney General Jeff Sessions in 2018. I think it was a strategic move to kind of deal with the fact that the cases over the executive order, the Trump administration is getting his ass kicked. They're basically losing in every district court. And I think they want to keep appealing and taking it up to the next level, but it's not even close so far. So they made some changes to it, some modifications, and what they did was they issued new conditions on a different type of very specific grant program. It was the Department of Justice Edward Byrne Memorial Grants. This is a law enforcement grant. It's pretty significant. There's hundreds of millions of dollars given out. Well, first of all, taxation is theft, since we know that the income tax day is coming up this next week. And we know, see, here's a great example. I'm looking in the chat. Stephanie says Trump is winning. And I think this is an example of ignoring what's happening on the ground. Now, you may not like it, but so far, his strategy in the courts, he's losing every single time. Now, he might be throwing a Hail Mary in the hopes that the Supreme Court is going to side with him. But we know the Supreme Court has actually not sided with him in this type of case for over 150 years, most recently in 2018, where they sided against the administration in 2018 as well on the sports betting case. Now, I don't think the Trump administration really defended that very aggressively there. But on top of it, I think what's more important, I'm just setting the foundation so you understand what type of cases there are before the federal courts. And then I'm actually going to explain to you how I think his strategy is risking making things worse. Because if he loses, this isn't just a win or lose. If he loses, the sanctuary cities and sanctuary states on immigration are actually going to be stronger than they are today, or they were 5 years ago, because he's opening the door to actually overturning one particular federal law on the books, 8 U.S.C. 1373, that is serving as a bit of a strategic roadblock on this to the sanctuary city policy. So the second type is they're actually narrowing it to these Edward Byrne Memorial Justice Grants. So you have to certify compliance again with 8 U.S.C. 1373. They have to permit DHS access to detention facilities, and they have to notify DHS upon request anytime someone is going to be released from prison within 48 hours. So DHS can go in there and get them. And so if the AG or the federal government certifies that anyone is not in compliance with those three conditions, then they lose federal funding under this particular law enforcement grant program. And then the third type of case is the California sanctuary state law. There are three of them on the books. One is SB 54, which bans the state from enforcing federal immigration laws. Not all of them, but in a narrow portion, broader than what has been done in most areas. Not Oregon. Oregon, I think, is the broadest of all of these so far. And their law was passed back in 1987. So SB 54, that is banning enforcement of immigration by state or local for the federal government without getting reimbursed. Then there's AB 103, which requires the state attorney general to do a report on the status of detention facilities. So Most of the detention facilities around the country are not run by, they may be run by the federal government, but they're actually owned by states. So, for example, the state has a facility and they lease it out to the federal government. So this law requires the AG in the state to actually report on the status of the facility. So then it also requires state agents to be able to enter the facility, and the feds don't want them to do that, and there's that conflict. And then the third one, which I think is really a problem, in my opinion, in California is AB 450. It's another law that actually bans private companies, private employers from voluntarily helping federal immigration. Now, this to me is the easiest win for the Trump administration, and so far this is the only one that they're winning on. It bans private employers from allowing immigration agents voluntarily access to what they call non-public areas. So if you run a business and there's a customer-facing area, then you can't stop them. But what they're telling private businesses is you're not allowed to have immigration agents back in your own office. It's a property rights issue. So I don't think anyone should be barred from voluntarily making a choice of who they want to let on their property and who they want to share their information with. And the state of California is trying to tell businesses, or has been telling businesses, that they're not allowed to do this unless the federal authorities get a warrant. I mean, this is private property rights, and that's a real problem. So let's look at 8/1373. And Justin Bayola makes a really good point here. I love how we are fighting whether or not feds can give money to states that don't comply instead of fighting whether or not they should have the money in the first place. And that really is the problem here. They shouldn't be taking the funds in the first place. But what I'm trying to cover here, and again, this is a rabbit hole. There's a lot to cover, but how the particular court strategy is likely to end up in a loss, and so far is a losing strategy. So let's look at 8 U.S.C. 1373. I'm going to pull this up here on the screen, I think. Hold on. Doing a lot of clicking. Okay. So 8 U.S.C. 1373 was passed in 1996, I believe, under the Clinton administration. Notwithstanding any other provision of federal, state, or local law, a federal, state, or local government entity or official may not prohibit or in any way restrict any government entity or official from sending to or receiving from the Immigration and Naturalization Service information regarding the citizenship or immigration status, lawful or unlawful, of any individual. For those of you who are like, what the hell did that mean? The short version is that it's a prohibition on a prohibition. The federal government has a law on the books passed under Bill Clinton, so this isn't a Trump thing. It isn't an Obama or a Bush thing. It was back under, let me just verify that this was. Yeah, it was the Immigrant Responsibility Act of 1996. So that was Bill. And he signed it into law. So it's a ban on a ban. The federal government takes the position that regarding immigration, no state or locality can have a law or a policy on the books where they no longer share information about the immigration status of a person. So what have most of these 300 plus immigration sanctuary cities done? They've actually passed laws or county ordinances that ban them from merely asking about immigration status. The short version is don't ask, don't tell. So the feds are saying on the one hand that you're not allowed to not share the information if you have it. And so the localities in response strategically are banning anyone from even asking. So what the Trump administration is doing, a lot of people think that the Trump administration is literally just trying to take away federal funding from all immigration sanctuary cities for not enforcing federal immigration law. This is not what they're doing. This is, I guess, government by press release or email forward. They're not even trying this. None of the court cases are even about this. They're literally trying to show compliance with 8 U.S.C. 1373. In two of the first three categories. The California sanctuary state case is certainly a little bit broader. But primarily, they want to be able to certify that local governments are not withholding information about the immigration status of individuals from the federal government. And they're saying, look, if you don't do this, we're going to take away either in category 1 all your funds, potentially, or 2, we're going to take away these law enforcement, this Byrne Memorial Law Enforcement Fund, this grant from the DHS and DOJ. So they're primarily focusing on this, but most of the sanctuary cities have a policy on the books that say we're not even going to ask. So I think if this is all they're really trying to do, they're going to have a hard time actually certifying that the information is being shared because they're just not collecting it. So hopefully this is not necessarily easy to explain, but hopefully that this is making some sense. Now the rulings in the federal district court so far in the 3 categories. First, against EO 13768, 13768, there have been three federal district court opinions. I shouldn't say rulings. And what they're actually doing is they've actually said that you can't actually do this. You can't take away grants by executive fiat. It has to be an agreement based upon what Congress passed when they passed the law. Otherwise, you're saying, okay, you've agreed to do this, or you haven't agreed to do this, and now we're attaching new conditions. Whether that's right or wrong is one thing, but that's what's been happening. Primarily, they've ruled against the federal government, the Trump administration, on those grounds in 3 rulings so far on EO 13768. 13768. If I misspeak on that, someone can correct me in the comments. I apologize. So far, there have been 3 opinions. They basically said you just can't attach new conditions on that. That is primarily coming out of San Francisco, Portland, Seattle. So you know how those judges are going to be leaning, of course, politically. Now, the second category was the 2018, the conditions on the Edward Byrne grants from Jeff Sessions. And there have actually been 9 opinions in the courts on 6 different cases. And in every single one of them, they're taking the same position, that you can't attach new reasons on funding. And then they're also, in most of those situations, they're actually taking a position against 8 U.S.C. 1373. I believe in one situation they said it was okay or they weren't going to address it. But in all the others, they're also suggesting or flat out saying that they're holding 8 U.S.C. 1373 to be unconstitutional commandeering. And that, I think, is the key point here. So those of you who support Trump trying to stop sanctuary cities, what's happening is he's taking this approach through the executive orders and through the Department of Justice and through the court system, and now he's exposing the biggest roadblock in federal law to being overturned by the federal courts. And we know from history, from 150 plus years, that the courts really, they have not been backing up anything that even looks remotely close to commandeering, requiring them to do something. And we can go back to what they said in 2018. Congress can't take any action that dictates what a state legislature may and may not do, even when the state action conflicts with federal law. So the idea of 8 U.S.C. 1373 is basically telling them that they can't have this policy on the books. And under current Supreme Court precedent, whether you agree with it or not, it is very unlikely that anything is going to happen other than this being overturned and it becoming a free-for-all where they don't even have to take this strategic approach by not asking. Think of all the different ways that they could do this. Now, if they wanted to actually provide a protection base or a real sanctuary for people who are in the country illegally, they could just literally ask. They're telling people not to ask, and in general, law enforcement is not asking. But let's say they say, now ask, and let's figure out who's here. We could run interference or something. They're creating a scenario where it's going to be much easier for the sanctuary cities to do what they've been doing. So that's 8 U.S.C. 1373. Now, the court cases on the California, the third category. Again, SB 54, the California Values Act, that's the sanctuary state law, so far in the one opinion. the federal government has not been able to require the state to help enforce so far, and I think it's iffy, so I'm going in order of where I think it'll play out. SB 54, I think even the Supreme Court will side with California on this, if it makes it that far. AB 103, the one that requires the Attorney General to do a report on facilities, I think this kind of gets into the conditions. Now, if the state made the conditions under the, let's say it's a state detention facility, and they make a deal to let the federal government use it, I think this gets to the idea of conditions. Now, if they didn't put that in the agreement originally and just start trying to attach new conditions, I think that the state of California is going to lose. Because if they didn't agree, if like a rental, for example, I have a rental property here, I live in a rental, and I have an agreement in my lease that says I can use this within certain parameters, and that the owners of the property can come in with certain notice for any reason. Now, if it doesn't say that with the federal government, then the state agents don't have the authority to go in and inspect the property. And I think that's probably how it'll play out. I'm not sure. I don't know the agreement between California and the federal government on these detention facilities. I do know that in response, it's very possible that California will cease to have these leases with the federal government. So then the federal government is going to have to find places to build new ones. And we know how hard it is for them to get funding. So again, this is exposing a problem that the feds are going to run into. And then AB 450, the third one in California, is the one that bans private employers from voluntarily cooperating with federal immigration agents. Basically saying you can't allow them to look at your records, even if you want to, even if it's your property. That's a real property rights issue. And so far, the feds have won on that one. The Trump administration, that's the only one that they've won so far. So before that Murphy case on 1373, it was split. Philadelphia, a case in Philadelphia said it was unconstitutional. In Chicago, that said it was okay. But I think even the Chicago case basically said, well, it's going to be up to another court. I'm not necessarily addressing it. Judge Orrick, I think it was an Obama guy up in Santa Clara, said that the federal government was doing commandeering, but didn't really address 1373. But since this Murphy case, since Samuel Alito and a 7-2 court case came out, said that you can't even tell the states what they can or cannot do, even if it directly conflicts with federal law. Every case that's been out there has sided with the states or cities against the Trump administration. And the Supreme Court itself has taken this position. So it's going to be very difficult for them to win this. And I think the warning that I have for both sides on this is it's twofold. If you want the Trump administration to stop sanctuary cities, I don't think this court case, this court approach, is a very good strategy. I don't actually have an answer to what they need to do, but it's a very risky one, because if the states win and 1373, or the cities win and 1373 gets struck down by the Supreme Court, then they're just going to go free for all. They're going to be able to remove these policies and go much broader in their immigration sanctuary policies. And on the other hand, it's interesting to see the left supporting federalism, saying that the federal government can't force anyone to do this. And people on the left, when the next leftist is in office at some point in the future, and localities finally, which I've been begging them to do for a long time, pushing very hard, start using this type of strategy against gun control efforts, it's going to be even more difficult for them to actually enforce this. And this is part of why we heard a lot of the liberal experts, the constitutional scholars and professors, coming out against anti-commandeering, wanting it to be overturned by the court itself, even though it just always takes the same position, was because they didn't want to see it play out that way. So I think both sides are playing with fire on this based on their views. These are the facts on the ground. I don't know. Hopefully you find this interesting. I want to share information with you, whether you think it's positive or negative, that you can find useful, so you understand what's happening beyond the crappy headlines on both sides. No one really is getting this right. No one's really explaining what's going on. Everyone, hopefully it's interesting. It's primarily about 8 U.S.C. 1373. the Trump administration really isn't trying to take away funding from everybody, at least not at this point. Maybe they're trying to get a foot in the door, but they're losing. They've lost on 12 of 13 counts so far. And the only one that they've won has been the one that I think is very obvious that they're going to win in higher courts and the Supreme Court. So looking over at the live chat, Bob O'Connell says it's leftist lies. Kim says, hi, everyone, first time here. Justin Bayola says, pad numbers. Paul Marone, good to see you, Paul. I'm not sure if it's Maroney. Says, greeting Tenthers. And Lee Evan Naher says, just became a member. I really appreciate that. Christopher Bell over on Facebook, good info. Keep up the good work. I will do my best. Mo says, how was it dealt with in the past? I'm not sure. I'm not sure how they do this. I think really the big problem here is the federal government has not done the job that many people want it to do in regards to immigration for a long time. And now they're basically grasping at straws, and they're going after things that are going to make it worse. That's my view. I think it is very likely that they continue to lose these cases in court. I wrote an article for The Hill about this right after Trump's first executive order. I think if the states and cities hold fast in their policy, they win on the ground and in court. And then on top of it, they're exposing the one roadblock in federal law to the immigration sanctuary cities to being overturned. Now, if you want the sanctuary cities stopped, you may not like that. But again, truth is truth. This is my opinion, and so far it's playing out that way. We'll see how it goes from here. And again, if you support the sanctuary cities, the odds are you're on the left. Most of the time you're on the left, and you like more centralized power. So in the future, this is not going to bode well for you either. This is not really a clear-cut win-lose case for people, and I think it's a very interesting situation. So hopefully you guys found this interesting, educational, fun to watch. I really appreciate you spending some time with me on a Friday or whenever you happen to be watching. If you enjoy the show, if you enjoy this show or the show overall, make sure to smash the like button, continue leaving comments. If you've got questions or suggestions for new episodes, feel free to email me over at team@10thamendmentcenter.com. Of course, I'll be back next week, Monday, Wednesday, Friday, 9:30 a.m. Pacific time, live on YouTube, Periscope, and Facebook. I think I'm going to expand to Twitch and maybe DLive in the near future now that we have the capacity to go even broader. And of course, we're over on iTunes, Google Play, Stitcher, Spotify, etc. All the places to subscribe and follow over at 10thamendmentcenter.com/Good Morning Liberty. Again, thank you so much for spending some time with me today. I really, really appreciate you joining me. I think it's awesome that you spent some time with me. And I'll see you guys next week. Have a wonderful weekend.